Grant of bail, though being a discretionary order, but however calls for exercise of such a discretion in a judicious manner and not as a matter of course. Stop. Order for bail bereft of any cogent reason cannot be sustained. Stop. Needless to record, however, that the grant of bail is dependent upon the contextual facts of the matter being dealt with by the court, and facts, however, do always vary from case to case. The nature of the offence is one of the basic considerations for the grant of bail. More heinous is the crime, the greater is the chance of rejection of the bail, though however dependent on factual matrix of the matter. Stop para. Apart from the above, certain other which may be attributed to the relevant considerations may also be noticed at this juncture, though however the same are only illustrative and not exhaustive, neither there can be any. Stop. The considerations being: A. While granting bail, the court has to keep in mind not only the nature of accusations but the severity of the punishment if the accusation entails a conviction, and the nature of evidence in support of accusations. Stop. Reasonable apprehensions of the witnesses being tampered with are the apprehension of there being a threat for the complainant should also weigh with the court in the matter of grant of bail. Stop. Para. While it is not expected to have the entire evidence establishing the guilt of the accused beyond reasonable doubt, but there ought always to be a prima facie satisfaction of the court in support of the charge. Stop. D. Frivolity in prosecution should also be considered, and it is only the element of genuineness that shall have to be considered in the matter of grant of bail, and in the event of there being some doubt as to the genuineness of the prosecution in the normal course of events, the accused is entitled to an order of bail. Stop para. The determination of whether a case is fit for the grant of bail involves the balancing of numerous factors, among which the nature of the offence, the severity of punishment, and a prima facie view of the involvement of the accused are important. Stop. No straitjacket formula exists for the courts to assess an application for the grant or rejection of bail. Stop. At the stage of assessing whether a case is fit for grant of bail, the court is not required to enter into a detailed analysis of the evidence on record to establish beyond reasonable doubt the commission of the crime by the accused. Stop. That is a matter for trial. However, the court is required to examine whether there is a prima facie or reasonable ground to believe that the accused had committed the offence, and on a balance of the considerations involved, the continued custody of the accused subserves the purpose of the criminal justice system. Stop. Where bail has been granted by a lower court, an appellate court must be slow to interfere and ought to be guided by the principles set out for the exercise of the power to set aside bail. Stop para. That thereafter this court considered the principles that guide while assessing the correctness of an order passed by the High Court granting bail. Stop. This court specifically observed and held that normally this court does not interfere with an order passed by the High Court granting or rejecting the bail to the accused. Stop. However, where the discretion of the High Court to grant bail has been exercised without the due application of mind or in contravention of the directions of this court, such an order granting bail is liable to be set aside.